It's 4 o'clock by my clock, by my watch, Central Time. So I don't know, Sherry, if you're still there, shall we get started?
Yeah, if Sherry gives permission, I'd love for us to get started. Hi, everybody. I'm Nancy Rapoport. I am the Garman Turner Gordon Professor of Law at the William S. Boyd School of Law at UNLV, and I know it's a mouthful. And we are the last panel of the day. When I first read the title of our panel, which is ethics, I thought, what is the closest analogy I can give you? And I was thinking, it's that scene in My Cousin Vinny, where Vinny and his girlfriend go into the restaurant, they look at the menu and they have a choice of breakfast. So they order breakfast and it was chef's choice. So this is now panelist choice on a variety of ethics topics. First, I'm going to do a brief intro of our three panelists. Professor Adrian Walters is the Ralph L. Brill Professor of Law at Chicago-Kent College of Law. He's also a visiting professor at his hometown institution, Nottingham Trent University in the UK. He focuses in particular on the US and UK systems in both his research and his teaching. Bob Fishman wins most recent move. He has just moved to Cozen O'Connor, and he represents a cross-section of parties in various insolvency proceedings. Among his other work, he served as the fee examiner in Detroit's Chapter 9 case. He's also a bankruptcy mediator, and he's served in a variety of roles at the American Bankruptcy Institute. In 2018, he received the ABI's Lifetime Achievement Award. Bob Keach is co-chair of Bernstein Shur's Business Restructuring and Insolvency Practice Group, and he's a past president of the ABI. He's been a fee examiner in a number of high-profile cases, and he was also the co-chair of the ABI's Commission to Study the Reform of Chapter 11. If you've been following along all day, you know that the goal is for our panel to be interactive, although each of our panelists will take the lead on certain topics. When you have questions, please put them in the Q&A. That's also where the CLE codes will appear. Let's start with Adrian and ethical issues involving closely held enterprises. Adrian?
Thank you, Nancy. The perennial ethics questions that arise, of course, in closely held enterprises in Chapter 11 cases is, can I safely represent the debtor entity and the owner principals? And in this type of case, the affairs of the entity and the owners will often be intertwined. Owners will often, perhaps invariably, want the same attorney representing themselves and the entity. There will commonly be a family angle, and the emotions of owners facing the loss of the businesses in which they're invested, and more than just financially invested, will be running high. Now, once the case gets filed, debtor counsel's client is, of course, a debtor in possession that owes fiduciary duties to the bankruptcy estate. And as the interests of owners and estate creditors may well diverge, there's a good prospect that actual conflicts of interest between the debtor in possession as fiduciary and the owners will arise. And so it doesn't need me to tell you that counseling the entity acting through its owners in properly discharging its fiduciary obligations in ways that may well run contrary to the owner's interests is not a straightforward matter. At the same time, there's a trade-off. Referring away some or all of the representation means more lawyers in cases where resources are already constrained. So there are stakes for clients and the system. Debtors have a right to employ the counsel of their choice. Dual representation has efficiency benefits, but there's a question of how far in an adversarial system, which depends on the participants receiving independent and impartial advice, we risk trading off the integrity of the system in the attempt to uphold client choice and promote efficiency. And so, of course, in order to protect the integrity of the system and protect creditor interests, there are also stakes if dual representation goes wrong. There's risks under state rules of professional conduct, and then there are the bankruptcy specific risks under the code, the risk you could get booted off the representation, the risk of fee sanctions under 328C of the code. I'm sure that many of you will have seen cases where objecting parties have deployed conflicts of interest strategically in an attempt to get debtors counsel disqualified or to get a trustee appointed under 1104 so as to terminate the managerial authority of the owner principals. Now, as in all fields of human endeavor which involve complex balancing of interests, there are several schools of thought and a spectrum of views running from the highly practical and flexible at one extreme to the very strict at the other extreme. And it's not surprising then that courts have taken a variety of approaches over the years, some adopting a per se rule against dual representation, others favoring a rebuttable presumption against dual representation, and yet still others at the more practical and flexible end of the spectrum favoring a case-by-case approach of the kind that we also see often in relation to the question whether there should be separate committees in jointly administered cases, which Bob Fishman is going to discuss. I framed the question when I started as, can I safely represent the debtor and the owners? But strictly, of course, the question for code purposes under section 327 is, will the court approve my retention as debtors counsel in circumstances where I also represent the owners? The section 327 tells us that the court will only approve retention if counsel is both a disinterested person and does not hold or represent an interest adverse to the estate. And these requirements not only have to be met at the time the court approves retention, but must be maintained throughout the case. And this principle that court-appointed professionals must strive to avoid conflicts of interest throughout their tenure is reinforced by 328C, which gives the bankruptcy court power to disallow compensation and expense reimbursement if at any time during their employment under section 327 they are not disinterested persons or they represent or hold an interest adverse to the estate's interest. Now, the code doesn't elaborate further on the meaning of holding an interest adverse to the estate, but disinterested persons is defined in section 101 as a person that is not a creditor, an equity security holder, or an insider, is not and was not within 2 years before the bankruptcy filing a director, officer, or employee of the debtor, and overlapping somewhat with the no adverse interest requirement of section 327 is a person that does not have an interest materially adverse to the interest of the estate or of any class of creditors or equity security holders by reason of, and I paraphrase, relationships to, connections with, or interests in the debtor. Here are 3 instances where in dual representation situations you could conceivably run into difficulty with the requirement not to represent an interest adverse to the estate. The first is where the owners also claim to be creditors, and so there could be grounds for claims objection, or the owners in their capacity as creditors are seeking favorable plan treatment. There's a well-known case called Rome versus Bernstein from up in Bob Keach's neck of the woods, in which an attorney who had concurrently represented the debtor in a Chapter 11 and the debtor's president and sole shareholder in an involuntary 7 had all his fees for representing the debtor in possession up to the point a trustee was appointed disallowed. And one of the many things going on in that case was that the attorney had filed no less than 3 plans of reorganization which provided for priority prepayment of insider loans. A second instance, also pertaining to claims resolution, is where the manner in which a creditor's claim gets treated will affect the extent of the owner's exposure under guarantees. And the third obvious instance is where the owners have been raiding the cookie jar by means of fraudulent transfers and preferences, and the estate has clawback causes of action against them under the avoiding powers. As a practical matter, it's of course essential that in the Rule 2014 disclosure accompanying an application for approval of retention under 327, that all the attorney's relevant connections are fully disclosed. Bob Keach is going to discuss Rule 2014, so I won't say too much about it, other than pointing out that failure to disclose is of itself an independent ground for disqualification or disallowance of fees, quite apart from a showing of actual conflict of interest. And again, the First Circuit so stated in the Rome versus Bernstein case I mentioned a few moments ago. And on the facts of that case, they held that the bankruptcy court had been well within its rights in denying compensation on the basis of failure to disclose alone, as well as being justified on the basis of several other findings of disqualifying conflicts in the record. The Ninth Circuit's Parker-Lehner case also illustrates the strict application of the disclosure rules, albeit there it was the attorney's failure to disclose the precise nature of the fee arrangement in violation of Rule 5016 that led to the denial of fees. The other provisions in the code I'll just highlight quickly concern retention as general or special counsel of an attorney who has acted before the commencement of the case for the debtor or for a creditor. There's no per se prohibition on employment as debtor's counsel because of the mere fact of prior representation. But of course, you do still have to meet the Section 327 disinterested person and no adverse interest standards at the time of the application for approval of retention and on an ongoing basis during the case. And you do, of course, have to make full and frank disclosure. On this slide, I've collected together what I will describe as a non-exclusive miscellany of Seventh Circuit and Northern District of Illinois case law, which underscores, I think, the main takeaways. There's plenty of cases where violation of disclosure requirements has not ended well. Rusty Jones, Tinley Plaza, and the Gloof Brothers cases are all good examples. Insofar as I can discern, courts around here are inclined towards a case-by-case approach. So if an actual conflict exists, then retention is probably going to get denied. But if there's a potential rather than an actual conflict, courts will use their discretion under the code provisions to determine whether, based on the particular facts of the case, the potential conflict is disqualifying or otherwise sanctionable. And in that regard, in rental systems is a good illustration. In rental systems, the presence of a significant potential conflict of interest exacerbated by tardy compliance with disclosure requirements resulted in Judge Lynch denying a retention application. The bottom line then is that if you take on dual representation, the inherent potential for conflict is always there. You are effectively in let's wait and see what happens mode. As such, as well as sound due diligence, you need to keep the situation constantly under review as the case unfolds because of the ongoing application of the 327 standards. At this point, with your permission, Nancy, I'd like to ask Bob Fishman and Bob Keach about their experience with debtor-owner conflicts, particularly in the smaller cases, and if there are any specific risk management practices that they would highlight or recommend.
That's a great segue. Bob's, what do you think?
I'll let Fishman go first, and then I'll pick up.
All right. I wish I had a I wish I had a delightful British accent to speak with. It would be more entertaining. Adrian is. It's easy to listen to him. Just the sound of his voice kind of makes me happy. I tend to adhere to the rule. I think it was actually on your slide at one point that if you even have to think about it, you shouldn't be doing it. There are, I suppose, cases where the owner of a company and the company's interests are so identically aligned that it might not be controversial. But in all the examples that you provided on your slide, such as insider as a lender or guarantor who might have slightly different ideas about how money should be utilized by the corporate entity to the indirect or direct benefit of the guarantor. Those are certainly great examples of when the debtor's lawyer can't be giving legal advice to the principal whose interests might very well be, and in fact likely are, adverse to the bankruptcy estate. More specifically, when it comes to a potential avoidable transfer, I mean, I don't think that's a line that even the most aggressive, ethicist, if there is such a word, would somehow be willing to imagine the possibility that you could represent the plaintiff and the defendant simultaneously, it's good work. You might be able to resolve the case by agreement, but I suspect that you're asking for some future difficulties, and so back to the rule of thumb, if you even have to think about it, you shouldn't be doing it.
Yeah, look, I think that's right. Look, I think you have to analyze it every time. But as I was listening to both Professor and Bob Fishman, I was trying to think in my mind, can I identify the one place where that advice might not be possible or might not have to be the case? And I can think of one or two, and they all involve sort of situations where the owner would not be any of the things on Professor Walters' checklist, right? Not a creditor, not a litigation target, not a guarantor, right? It seems to me if those are the situations, then you have a chance. You still have to obviously analyze the circumstance, because even as an owner in a non-SBRA case, and I want to talk about is there an SBRA wrinkle in a second, since I had a little something to do with that, Bill. But in a non-SBRA context, it seems to me, even if you're just an owner and there's an issue around absolute priority or new value or anything else, as there often is, right? In other words, if you're not in a fully consensual plan that doesn't raise any of those issues, it seems to me you need separate counsel for the owner, right? Or at the very least, you as the DIP lawyer cannot counsel the owner qua owner, right? The problem, of course, is you're always talking to that person and he doesn't know which hat, he or she doesn't always know which hat they have on. And you can't always tell which hat they have on either, even when they actually are wearing the hat. So, I mean, it seems to me it's on you to make sure that, you know, you're identifying in which capacity you're communicating in. And when they need separate counsel, you need to make sure you're telling them that. The SBRA wrinkle, I think, is interesting here. And I sat through the SBRA program. There was some discussion around when SBRA, you know, owners would need separate counsel. And remember, in the SBRA kind of default cram down mode, when you use the 3 to 5 years of disposable income, you no longer need an accepting impaired class, and the absolute priority rule does not apply, right? So I think in that case, if your insider is purely the owner, those interests are almost perfectly in concert. I still think you've got issues when the ownership becomes any of those other things. I'm not sure how you get around that, but it may be a simpler case in an SBRA case now that we have no absolute priority rule and you don't need an accepting impaired class. It may be a little easier in the pure owner case to not get separate counsel, but even then I'd have to think about it. You know, what's the plan look like? Where's the money going? Is there insider debt that's going to be serviced under the plan? I mean, all of those things could come to play, and then we'd be back to the default, which is just get separate counsel. And then I think in the one instance where if the real property is owned by the individual and the individual has the opportunity to do something you can't do anywhere else, which is modify, you know, first mortgage debt on a residence if it was used to fund the business. And it may make sense for the individual to file his or her own sub 5, and clearly they've got to get separate counsel then, right? So it seems to me the window is pretty small.
I thought that in the hypothetical that the panel used in the SBRA case, where the principal was deciding to pay the mortgage payments in full, and even in their own hypothetical, they opined that the reason he was doing that was because of the personal guarantee. I thought that was just an obvious example of a situation in which somebody could get highly criticized for implementing cash flow decisions that were so clearly of direct benefit to the insider guarantor and may or may not have been beneficial to the unsecured creditors. So they posed that question, and I thought that it was clearly a case where they would need separate counsel.
Yeah, I think that's right, because in the hypothetical they gave, the property was significantly underwater, right? Might be a different situation if the secured creditor was actually fully secured and therefore entitled to be paid in full no matter what, right?
So I think the life lesson here is that people really need to think deliberately before deciding whether to take on the representation. And one of the things, just from a social science perspective, that I want to remind people of is that even the smartest people are really good at fooling themselves and talking themselves into dumb things that in retrospect will cost them time and will likely cost them fees. With that,
and I think the professor made a good point, which is, I mean, we'll get to this when I start talking about 2014. I'm not sure you're going to get past the gate in most circumstances when a filing happens. So this really is a decision you have to think about pre-filing, right? Because in all the cases we're talking about where, as Bob, you know, I like the Fishman rule, which is if you have to think about it, yeah, just go ahead and do something else. But that thought ought to come to you before filing, because I'm not sure you're going to get through the gate if you wait all the way to filing.
I think that's true. Well, let's segue briefly into Bob Fishman. Tell us a little bit about the challenges involved with creditors committee in jointly administered cases.
Okay, let me start by saying I'm not going to go through my PowerPoint. I think the materials are good. I think that they're got some good legal analysis and will be beneficial to you if you ever are trying to write a brief or engage in a legal argument on this issue. But I think the policy and practical considerations, the discussion points are really what I'd like to try to highlight here. There's been an ever-changing evolution in bankruptcy cases, and especially as it relates to committees. Over the course of the history of the bankruptcy code. When I was a young lawyer, a creditors committee was vendors. I mean, that's entirely what a creditors committee was made up of. And they could easily have differences of opinion about what to do about a case, but there was no inherent ethical conflicts between the legal positions of the members of the committee. And I think that enabled them to fulfill their fiduciary duties without having to be, by definition, inconsistent with their own interests as an individual creditor. And in those days, the fiduciary duty responsibility, I think, was fairly easily fulfilled. Of course, over time, there's been quite an evolution in cases, and accordingly, quite an evolution in creditors committees. Vendors do still occasionally get to be on creditors committees, but if you represent vendors trying to get on creditors committee in big cases, you know that those are crowded rooms and long lines. And it's not always a given that the largest unsecured vendors are going to get on a committee. We had a case down in Texas where we represented the second largest vendor, a multi-million-dollar claimant. And the U.S. trustee in the Northern District of Texas did not see fit to put our client on the committee because the committee needed so many other kinds of constituents, according to the U.S. trustee. So who else do we see on committees? Landlords are now on committees. Intellectually, that bothers me. I think landlords have an inherent conflict of interest with the fiduciary duty they owe to the creditor body at large, but they're on the committee. If you happen to have a tort case, tort claimants, they're a unique claimant. I don't really disagree that tort claimants belong on creditors committees in those kinds of cases, but they're a different kind of claimant. There's a lot of unsecured bonds out there in the world today. Unsecured bondholders are financial investors and not vendors, and they too have an entirely different financial interest in the case than does the typical trade creditors. Employees can find themselves on creditors committees. That's another group of creditors with a kind of unique set of rights and responsibilities, and their individual interests are not typical of the rest of the members of the creditor body, and even pension funds. And by virtue of insolvent pension funds, the Pension Benefit Guaranty Corporation finds their way onto creditors' committees. And I think the existence of all those kinds of parties makes for some complicated negotiations in the creditors' committee room about what things we're in favor of and what things we're not in favor of. There are legal complications to what it is that creditors think is pertinent in deliberations as members of a committee. The two things that come to mind most specifically are critical vendor orders and the new and improved 503b9 claims. And so those sacrosanct, sort of pristine vendors who were originally the constituents that comprised creditors committees and who creditors committees were really about, they too now come with some baggage. Because if the bulk of your claim is going to be paid under a critical vendor order, or the bulk of your claim is entitled to 503b9 treatment, then your interest in the case is a lot different than if you're a multi-million-dollar unsecured creditor who just is trying to figure out how to get paid. Let's add to the mix multiple debtors, sometimes 50 or 60 or 70 multiple debtors. And those multiple debtors have different creditor constituencies comprised of different kinds of creditors. And so when you overlay multifaceted creditor bodies with multifaceted cases, you have an exponentially more difficult situation. Now, what's behind all these issues from a practical standpoint? I think that it's fairly clearly the never-ending struggle for who's going to control the case. And the creditors committee has an internal struggle and an external struggle simultaneously. You have a struggle over who's going to control the creditors committee, and then you have a struggle over how much control is the creditors committee going to have over the case. And in the context of the case, you have debtor or debtors, each struggling to maintain control over the case. You have committee or committees also struggling to maintain control over the case. And undoubtedly, you have one or more secured creditors who not only is struggling to maintain control over the case, they believe that they are divinely entitled to control the case, and typically act as though everyone else should already understand that. And it makes for a complex environment in which creditors are supposed to engage in and fulfill their fiduciary duties under 1102A, as all members of all creditors committees are accordingly charged with that responsibility. And the fiduciary duty is really clear. It's to the creditor body. It's not to the creditors who look like you or who feel like you feel, or who have claims that are like the claims that you have.
Bob, let me interrupt you for just a second, because you're raising a lot of important points. Let's say you have someone who, there's two types of people on creditors committees: people who've done it before in other cases, and new people who go on for the first time. How do you operationalize your advice to the newer types of people so that they don't cross the fiduciary line? What sorts of guidance do you give them? They know in the abstract what fiduciary duty is, but you don't want them to find out later they've gone wrong.
Well, it's a good question. Frankly, I'm not sure my advice to members of a creditors committee is a lot different, whether they're new or whether they're very experienced. I'm not sure that some of the most experienced committee representatives aren't the ones most likely to cross the fiduciary duty line because they think they know how the game is played and they think they know where the boundaries are, and they may have gotten away with things in another case and they feel like they can get away with them again. I think that it's really important for counsel to advise a committee about the boundaries and responsibilities. Part of the process is to implement a procedure for the committee's business operation, which is confidential, which is thorough, which is well managed, which keeps pertinent information from finding its way into inappropriate places. But largely you have to rely on people's willingness to adhere to the legal requirements of being a fiduciary, which is act in the best interest of everyone. And it's really hard to supplant what's in your best interest with what's in everybody's best interest when you likely view what's in everybody's best interest as being the same as what's in your best interest.
Yeah.
And if our current political environment doesn't teach us that that's the way everybody thinks, I don't know what does.
Well, with that, Bob, let me just jump in and before you get yourself in more trouble, because that would be me. I mean, I would get myself in more trouble if we continued down that line. Let me make one point and then one question. One point is in my materials is a cite to a case called Fibermark, which was actually fundamentally about, shall we say, groups that travel together and represent creditors committees, right? In other words, right? And in fact, professional creditors committee members who regularly retain the same group of professionals. And the issue in that case was whether or not the committee professionals had too much loyalty to the regulars, right, who brought them there, as opposed to the constituency as a whole. And I'll make no comment on the subject other than I would suggest you can find the late Harvey Miller's examiner's report online, and you can find Judge Brown's very thoughtful opinions online. And I would commend them to people, faced with that issue. The only other point, and this talks more about potential remedies to your problem, but something I'm seeing. I've just become involved in a case, the fee examiner in a case, where there are multiple debtors, and there are multiple debtors sort of at different vertical stops in the cap structure, right? Or in the organizational structure, I should say. And it is anticipated that there are potentially issues about where distributions will lie from, certain assets at which points of the org structure, right? So parent, first sub, second sub, and so on. And so I think quite rightly what's happened in that case is that there's an independent board committee at each of those levels. And the independent board committees, which consist largely of a couple of people in each case, have their own lawyers, their own financial advisor. They have local counsel and lead counsel and their own financial advisor, right? There is a single committee that represents the creditors of the corporate group, as the circumstances you just talked about. I guess, let me just put the question to you, is that a structure that we're going to start see replicating itself? In other words, is the independent committee structure the way to go there to deal with some of those problems? It certainly, I think, fixes the debtors board's issues. Whether it fixes the creditors committee problems, you're talking about maybe another question, but maybe it mitigates them. I throw that out. But it highlights the problem. We have a lot of lawyers and a lot of financial advisors, right? So, yeah.
You read the third page of my outline. So I think that the question you ask is a good one, because eventually you get to the point where you say, okay, so what do we do about this? I'm just not quite there yet, but I'm working my way to it. So the single committee, with its inherent conflicts, most of which are issue conflicts, and which are reasonable differences of opinion that members of creditors committees can have and can appropriately utilize to make decisions for what's good for the entire constituency, get more complicated when you get some intercompany issues mixed into it. So when company A in the capital structure has a claim against company B, and company B has a claim against company C, and company C has a claim against company A, and all of those claims are hotly disputed, and none of them are the kind of claims where we'd say, well, that, write a check, it's obvious. And you have a single creditors committee, and the single creditors committee has creditors from company A and company B and company C all sitting on it. It's really hard for me to figure out how the committee can fulfill a fiduciary duty to creditors in 3 different bankruptcy estates that clearly have 3 different best interests. No one best interest suits them all. In fact, what's in the best interest of company A is to the great detriment of company B. And the ethical issue, though, is you're the lawyer for that committee. How are you giving that committee legal advice about whose claim is better and whose defense is better, and how you fulfill your fiduciary duty in representing as an actual creditor of company A, the constituency in companies B and C that you owe a fiduciary duty to? I find that trying to be a lawyer or a financial advisor and giving advice about how to analyze the case, how to weigh the claims and the defenses, and how the individual committee members should be thinking about those things in terms of deciding what the creditors committee position ought to be, are really complicated. Substantive consolidation potential is another issue that really triggers these same kind of complexities, because substantive consolidation might be really good for the creditors of one of those 3 companies and dilutive in a big way to the creditors of another of those companies. And then you can further complicate the case by having different business operations in the different companies, where they buy and sell things to and for each other, where they license different assets to each other, where their unsecured creditors are different, and maybe most importantly, where their secured creditors are different, because those secured creditors are the ones who have their foot on either the gas pedal or the accelerator, or the brake, and they're pushing the buttons that sort of dictate how the debtors are going to have to deal with those issues, and then a single creditors committee tries to act consistent with its fiduciary duty in such a multidimensional setting. Now, multiple committees is one of the choices, and under the law, there's a minority of courts that think that in the kind of circumstances I've described, you need multiple committees. The majority of cases go to the ever favored case-by-case basis, which is, I don't know, let's figure it out. Those cases are based almost entirely on practical considerations. The functionality of the committee is one of the main things. Is this committee at war with itself? Are they having 3-3-2 votes on every issue? Or are they able to reach a consensus? The nature of the case, which has to do with the capital structure and the business and the kind of claims that the entities have against each other, is really important. Remembering that if somebody wants a separate committee as the movement, the burden is on them to show that it is necessary. And so the motivation of the movement is going to be important. And that motivation might be strategic or it might be financial. I don't want to fight that fight on my own nickel. I want to fight that fight with the estate's nickel. Or the committee says that's a legitimate fight, but use your own nickel because we don't want to pay for it. And then sort of the overall cost to the possibility of multiple committees to the case's ability to survive is very important, because administrative insolvency brought on by massive professional fees that a case can't endure is an important consideration. I think that the driving issue here is the courts look at conflicts with a small c. And I'm not sure whatever happened to the analysis of conflicts with a big C. The ethical conflicts that lawyers have under applicable state law don't show up in the legal analysis in these cases. It's all about the practical conflicts, liquidation versus reorganization, debt holders versus trade vendors, senior versus subordinate creditors, holders of plaintiffs in intercompany claims situation versus holders of defendants in intercompany claims. And those are not ethical conflicts, those are strategic conflicts. And committees can live with strategic conflicts. It's the ethical conflicts that I think are the harder ones to solve. Now, what are the alternatives? You have a single committee and you live with it and do the best you can. That seems to be what most courts end up deciding to do for practical reasons, not because they think that's the right outcome. You can have multiple committees. There certainly are cases like that. And if the case can afford it, that's probably the best way to keep everybody on the right fiduciary path. Courts have suggested the appointment of examiners to deal with those kinds of issues so that the committee doesn't have to carry the water on that. I'm not sure how helpful that is because the committee still needs to take a position, and if the majority of creditors are not helped by the examiner's view of the world, then likely the committee is going to take a position contrary to the examiner. And I don't know that the examiner might help the court, but I don't know if the examiner is going to help the committee. And lastly, what Bob mentioned, which is a fairly new phenomenon, and it goes right back to the who's going to control the case question, which is the existence of independent directors and managers and independent counsel and financial advisors for the various debtors who do the investigations and possibly handle the intercompany conflicts, and the main debtors counsel steps out of that fray. And that's exactly the way Toys R Us was handled. We didn't get to find out if that was going to work in the long run or not because the Toys R Us business didn't support the bankruptcy case long enough. The business went south, and the legal issues lost a lot of their vitality. The case that you mentioned is kind of the Toys R Us model. I think there's a lot of vitality to that, but it ignores what I think is the most meaningful question, which is, we all know what happens when a debtor has internal conflicts. They have to get independent counsel. We just talked about that while Adrian was talking. Why is there a difference in the legal outcome for committee conflicts and debtor conflicts? I'm not sure I can identify the basis for that. Courts seem to be able to do it entirely on a practical analysis basis. And I think one of these days a court's going to say a conflict's a conflict's a conflict, and you can't have one. So with that, I invite everybody's comments.
Well, Bob, I think one of the big takeaways I think is important for people, and it'll be a good segue for some stuff later, is the point you made earlier, which is we're very good at creating constructs to deal with practical problems of representation in bankruptcy cases, right? Conflicts counsel, which is extremely prevalent in large cases, right? Efficiency counsel, right? We don't often ask ourselves the question about whether any of those constructs actually solve the state disciplinary and professional responsibility questions.
Correct.
And oftentimes, of course, they don't, right? We're just counting on the fact that something bad's not going to happen because we put the construct in place, right? But if something really does fall apart, none of those orders is going to save you from state bar counsel.
I'm just waiting for a court to rely on 105 to solve this problem.
There are a few articles on Point that talk about how to think of these types of shifting, risky conflicts. And If folks want that later, I'm happy to email some things to them. But Bob Keach, you get a chance to talk about some of the, and I use this phrase, I guess, advisedly, but I'm an ethics geek, some of the sexier things left to talk about in terms of ethics for the rest of our period.
Sure, and other than showing that slide, Adrian, you can take my slides down because I'm going to go through the stuff pretty quickly. But look, I'm going to talk in reference to, I'm not going to go through in particular, but I'm going to talk in reference to two relatively current cases. The McKinsey, Marbo, Alex fight, which as people know is multiple cases. And then at the end, we're going to talk a little bit about something we hadn't planned to talk about, we're going to talk about anyway, which is a recent case out of New York called, involving Marble Ridge and Neiman Marcus. And I picked those two things because I wanted to make sure I wasn't talking about anything that was very controversial. So with that, and you can take the slides down if you want. Thank you. I also want to start, right, because it's kind of a nice bookend, with the case that, and I'm going to talk about 2014, and Adrian's already done some work for me by telling you about the rule and about the things it's trying to enforce. But as 2014, as we all know, is the rule that requires when we seek retention for us to disclose, for professionals seeking retention, to disclose all connections, right? And it's all connections with a list of people, but at the end of the day, it's pretty much all connections to anybody involved with the case, or who might be involved with the case. And it is a kind of strict liability construct, by the way. It doesn't say all connections you know about, or all the connections you found, or all the connections you had a reasonable cause to know about. It's all connections. So with that, I want to start with my first, what I call the cautionary tale. And it's certainly the case that got my generation of lawyers' attention. And that's United States versus Jolene, right? 21 years ago, I know from the fact that I supervise a lot of lawyers younger than me in my office, there are a lot of people who don't know about Jolene, but you probably ought to read the case. Mr. Jolene was a New York bankruptcy lawyer at a respected New York firm who represented a debtor, and in connection with that filed all the usual retention papers. There were a couple of entities that were discovered in the course of the conflict search that the firm and Mr. Jolene made the judgment that they did not need to disclose. In other words, those connections were not material enough to disclose, and so they didn't disclose them. And it turned out that decision was wrong. As it turned out, they became very material. Even though Mr. Jolene basically said, look, I just made a poor judgment, but I didn't really mean anything by it. Mr. Jolene was convicted under 18 USC 152, fined $15,000 and sent to jail for 15 months. So if you need sort of, a sense of where the stakes are, that's where the stakes are. 18 152 has a false oath provision. And if you haven't noticed, somebody signs the declaration, the affidavit, when you file retention papers. And if that affidavit is inaccurate, and it's knowingly and fraudulently inaccurate, we're going to talk a little bit later about what those two things mean, you can go to jail. So it's something you probably ought to be careful about. Let's move to the less kind of draconian, but no less important cases that I call the classics. And if you're in this area, you need to make sure you read, in my mind, you need to make sure you read three cases. One is Leslie Fay, which I think everybody knows about. And Leslie Fay, I think, establishes what I will call the classical absolutist nature of 2014, right? It says all connections. And therefore, you have to disclose all connections. You don't make the choice about which ones are material or relevant. The court does. And the court in Leslie Fay made it very clear that that's the case. So it's not for you to sift on a relevancy or materiality basis. You have to disclose all the connections. Granite Partners, which followed that case, another Southern District of New York case, is of a similar vein, but makes it very clear that the consequences of failing to disclose connections can be very serious. People used to talk about the consequences of this being the 3 Ds, which were, I think, if I'm remembering correctly, disqualification, disgorgement, or disciplinary action. I think you could actually put one before you got to disqualification, which is denial of retention, another D, right? I actually think you can add a few more if you think back about Jolene, and those are detention, disbarment, and disgrace. And I'm sure if I kept thinking about it, I could go farther, right? But, you know, obviously it's serious. But Leslie Fay and Granite Partners, I think, established this kind of absolutist nature of 2014 because strictly read, 2014 has no qualifier, right? But an important case to read, and I think she doesn't get nearly enough, you know, credit for this, is Judge Colleen Brown's opinion in Fibermark. Because what Judge Brown says in Fibermark is, I read it, I see that the statute is absolutist, but you can't possibly apply it in that fashion in real life, right? In other words, it has to be only the connections you know about. It's kind of impossible, you know, to disclose unknown connections. You find yourself in one of those, you know, Roku poems made out of like, you know, I forget, you know, the Secretary of Defense who was famous for this kind of thing, but the known unknowns, right? Is that Rumsfeld? But yeah, so, you know, it's hard to know the unknowns and it's hard to disclose them. So her point was, and her question was that the questions are how far it is reasonable to assume the rule was intended to go. And by what factors, if any, the strict construction of the rule should be tempered, right? That's a quote from the case. In other words, it's not practical, either from an expense standpoint or just a reality standpoint, to apply it literally, right? So where are the boundaries? And one final point she made, and then we'll get to talking about it, is the distinction must be made between situations and involvement in other cases that are disclosed just because they could conceivably fit within the broadest definition of connections, and those that suggest an appearance of a conflict of interest or lack of disinterestedness. In other words, there's some stuff that connections that genuinely doesn't matter, right? We're both members of the ABI, right? I mean, I have disclosed that, you know, my ABI connections in lots of cases, but the fact that Bob Fishman and I are both members of the ABI is a connection, but it may not mean much, right? And so part of the journey after, you know, the Leslie Fay to Fibermark point is what's the line? I've spent a lot of time in the last few weeks looking at roughly, I think I'm up to almost 50 declarations and supplemental declarations in the case I've just become fee examiner in. And I think one of the lessons we can draw out of the case that I first referred to, which is the entire Alex Marbo McKinsey mess, and some of the opinions that have come out of that, without taking any sides in the case, by the way. And one of the things that really dawned on me after reviewing all of these recent retention docs and seeing the fact that people were retained is that I think it's become very process oriented. And what's the big reveal is that it's not what you disclose. The short answer to that question is whatever you find, right? I mean, again, it's not your choice. Go back to Judge Brosman's early admonition. Once you find something, you shouldn't be doing the sifting, right? And so to me, it's easy what to decide to disclose. And there are some issues around confidential client names and the like, and I'll touch on that briefly. But I think those are workable. Those are workable if you want to. But I think it's not so much what you disclose, which is everything you know or find, but how and where you look in the form of disclosure, right? And so what that means, and I have argued in my materials, and I know the so-called Houston Protocol got a lot of grief when it came out, largely because it was just another thing thrown into the pit of the battle, right? But frankly, anything that Jan Baker writes in seriousness, I think you should take seriously. And when he's aided by, you know, Paul Singer, even more so. But everything Jan thinks about seriously and writes seriously, I think is worth serious consideration. And given that he crafted the Houston Protocol pro bono, I think it even requires more serious consideration. And that's not to say that everything in it I agree with, but if you want a sort of best practices manual, it's not a bad place to start. And what does he talk about? Well, he talks about it's really important how you define the interested parties list that you're checking to begin with, right? That list needs to be comprehensive. You know, the debtor is the first one to create that list. They're the ones with the knowledge, but it's certainly on the other professionals to make sure that the list is complete, right? And ultimately on the court. So start with the broadest list possible, right? And then you have to have a multifaceted search within your law firm. You can use your software and your conflicts checking system, but that's probably not good enough. And then it also depends on who you're going to use it with when we get to things like investment vehicles, for example. And larger firms have investment vehicles, and your partners make investments. And there are limits to where you have to go. Do you have to, I don't know what's in my mutual funds. I don't think you have to look there. But if your firm's running an investment vehicle and investing in clients or investing in other professionals, I think you've got to look there. And I think you need to send a questionnaire to every member of your firm, and maybe not just to the lawyers, about things like investments and relationships and the like. And then you need to keep doing it as the case goes on. And I would say the best retention applications I see are the ones that show their work, right? This is what I did, right? The long form version of what I did with my summer vacation. This is where I looked. This is how long my reach back period was. This is how far back I looked to consider whether somebody was current or not current. And here are all the other things I did. In other words, lay it all out. And what I'm seeing in the interaction between the U.S. Trustee's Office and professionals is largely that. Did you look in all the right places? Because again, it's not so much what you disclose, aside from one issue I'll go to, but what you did and whether you show your work or not. Now, the issue around confidential clients, which was a huge issue in that fight, there are now two opinions about. And the short answer is you have a duty to ask your clients whether you can disclose their names or not, if it's truly confidential, and not everything is. I think you have to analyze whether it is or it isn't. And if you can't ask their names for public disclosure, you should ask whether you can at least disclose them in camera, because that was one of the solutions in the McKinsey fight. And eventually, you should file a deck that discloses as much as you can disclose in that circumstance. But I think the issue around confidentiality of client relationships is a bit of a red herring. I think you can usually work it out by either getting permission, disclosing in camera, or making an adequate description of the situation that allows people to assess whether or not it really is affecting your disinterestedness or whether you have a conflict. Skipping quickly, and you'll see that in my materials, skipping quickly to the whole situation around Marble Ridge. I'm going to presume most people know the facts, but the short answer of the case is that somebody, and we know that some of the people involved, so I'm not going to use names or firms, you can go read about it, but somebody got in very deep trouble, essentially attempting or allegedly attempting to influence somebody else to not bid on an asset they wanted to bid for. And they did so while they were chairing or one of the co-chairs of the creditors committee. So we can all sort of think about what those implications are. But the thing that immediately jumped to mind for me, because I was brought in post-auction in a case a long time ago to represent somebody who was accused of 363N collusion in bidding complications, who also went on to get indicted later on, actually avoided indictment, was being considered for indictment, and we managed to not have him get indicted. Somebody else got indicted, but not him. And the point I want to make when I read that case is that what most people don't realize is that it's easier to commit a bankruptcy crime in that context than it is to run afoul of 363N, right? 363N requires an agreement among potential bidders that controls the outcome of a sale, right? And actually you have to intend to control the outcome and you have to succeed, right? 152.6, 18 152.6, everybody should go back and read it again. says that a person who knowingly and fraudulently gives, offers, receives, or attempts to obtain any money, property, remuneration, compensation, reward, advantage, or promise thereof for acting or forbearing to act in any case under Title 11 can be fined and imprisoned. And I would submit to you, if you take the knowing and fraudulently off the top, that's everything else down there is called deal making, right? That's just making a deal. So the issue is whether you knowingly or fraudulently made a deal, i.e. did you do a secret deal? And the way I segue these two cases together, because I'm running out of time, is guess what establishes that you have committed, that you were doing it fraudulently most of the time? Failure to disclose, right? When you don't disclose stuff up front and you later on get caught and you say, hey, I didn't really mean to do anything, see Jolene, by and large, it doesn't work. So let me stop there.
So I think the bottom line for all of this, it's a little Watergatey. It's not the crime, it's the cover-up. The other thing that I think is important for people to remember is ethics is part of your bar card, right? You have to know what, as Bob Fishman said, it's not just the bankruptcy side of things, it's the state side of things. Knowing it can maybe keep you out of trouble. Not knowing it can get you in all sorts of trouble that can lead potentially to prison orange. With that, I want to thank the three panelists. You guys were a dream team, and I will turn it back over to Rick Bendix.
Thank you, Nancy. And thank you to all of the moderators and panelists for an outstanding program. Despite having worked out this morning, I stayed awake through the whole thing, and I found it absolutely fascinating. I know you guys, everybody, did a lot of work, and it shows in the quality of the presentation and in the quality of the dialogue back and forth. So on behalf of the committee and everybody else, I want to thank everyone for an excellent job. And attendees, please be on the lookout for an email in your inbox that you can use to record your CLE codes and get CLE credit for this, this wonderful program. And with that, I wish we could all gather in the foyer of the Chicago-Kent Law School for a drink, but I guess we'll all head to the bar and have drinks on our own. So have a wonderful weekend. Thanks again. And I hope we see you all next year at the 12th annual seminar. Thanks and have a great weekend. Bye.